Hello, folks. Welcome back to the Wikipedia world, and I am Abhinay Gupta. So today again we'll be continuing with the winding up of the companies, right? And for this chapter we'll be referring to the provisions of the Companies Act 1956, right? So the basic topic for consideration in today's lecture would be the winding up of the companies voluntarily by the members, right? That is the members voluntary winding up. So before this, we have already covered the compulsory winding up by the court, right? We have discussed in detail all the various provisions that are related to it and the other important topics that relates to it, right? Like who the liquidator is and everything. What is his power? What is dissolution? Right? What is the statement of affairs and stuff? So all the things that were related to the compulsory winding up have already been covered in the previous lecture. So anyone of you looking for any of those topics, please refer back to the other lectures that have already been covered, right? And in the previous lecture also we have discussed in detail what voluntary winding up is, right? Where you understood that yes, there is a difference, right? A thin line difference between compulsory winding up and voluntary winding up, right? So today when specifically we are covering the members voluntary winding up, we mean to say that this is the category of winding up whereby you have no intervention of the court, right? This is done by the members themselves. And you also know that when we talk about voluntary winding up, there are two categories of voluntary winding up. One is the voluntary winding up by the members of the company, and the other is the voluntary winding up by the creditors of the company. So do you know what is the basic difference between the two? Both of it is voluntary. Yeah, some of you must be saying, yes, sir, one is done by the members and the other is done by the creditors. Agreed. But what are the situations, right? Based on which circumstances, what circumstances lead to these kinds of winding up? So, if you talk about the circumstance, then I would say the prime difference between the members voluntary winding up and the creditors voluntary winding up would be the declaration of solvency. In members voluntary winding up, the directors they issue a declaration of solvency to the court, right? But in creditors voluntary winding up, you do not require the declaration of solvency. Why? Because in members voluntary winding up, you actually are solvent. Only when you are solvent, you can hold the members voluntary winding up. You can say that yes, we are in a position to pay off all the debts. Either we have no debts or whatever we have, we can pay them off. We have surplus fund, we have enough money, we are running in a good state, but still we need to shut down the company due to any reason. We'll talk about it when we are discussing it in the lecture. But the crux is that you have surplus fund, right? And you can conclude the winding up proceeding successfully. Whereas when we talk about creditors voluntary winding up, that situation arises when the company goes insolvent, right? When we know that the company does not have surplus fund to pay off all its liabilities and all its creditors, right? Neither does it have such fund, nor can it realize that fund from sale of its asset, nor that fund can be arranged from the contributories. That means at the end, even if you follow all the winding up proceedings very well, you will not have enough money to pay off all your debts, right? So in that case, you have to go on with the payments in the order of preference, where you have the preferential payment, where you have overriding preferential payments as well, and all that list, right? We'll talk about it later in the chapter when we refer to that point of the priority of payment, right? So far you just need to know that yeah, there are basically two categories. One is the preferential and the other is the overriding preferential, and the third is obviously the unsecured people. So that is a separate issue, a separate topic altogether. So what we actually mean to say is that creditors voluntary winding up comes into play when the company is insolvent. And you know, creditors voluntary winding up can also be initiated after or during the members voluntary winding up. That means yes, there can be a situation where the voluntary winding up was initiated by the members, right? It started as a members voluntary winding up, but due to some unforeseen circumstance or due to some miscalculation in the declaration of solvency or something, the company went insolvent, and that was not predictable. right? Because if it was predictable, you would not have gone for members voluntary winding up. The only uh, circumstance that yes, you went for a members voluntary winding up is that you considered your company to be solvent, right? But in the process, if once you come to know that it is insolvent or it appears to be insolvent or there is certain situation that have occurred which makes it insolvent, then from then you will stop members voluntary winding up and you will continue with creditors voluntary winding up. That means the same liquidator will continue the same proceedings or will change the proceeding based on the preference of payment and stuff, but he would continue the second half of that voluntary winding up as creditors voluntary winding up, right? So I think now you got a zest, you got a frame within which you got a scope within which you need to think when we're talking about members voluntary winding up. So if that scope has been created, if that frame of thought has been created, we can get into it and discuss the members voluntary winding up in detail, right? So in a common parlance, we say that the members voluntary winding up would be initiated with the appointment of the liquidator, right? But I would say no. The members voluntary winding up basically gets initiated with the preparation of that declaration of solvency by the directors, right? In the previous lecture, we have already covered what declaration of solvency is in detail, so I would not get into the topic in detail now, but yeah, I would share it. I would share the concept of declaration of solvency with you again today in the lecture. So basically, the declaration of solvency is prepared by the directors or the officers of the company for the purpose by majority of directors, yeah, sorry, minimum 2 if there are 2 directors, right? So what is the purpose of declaration of solvency? So the directors basically they go ahead to prepare a statement, to prepare a declaration, to show the court and to show the official liquidator that yes, we are solvent. That means we have enough fund with us, available with us, so that we can pay off all the assets that we have, or sorry, all the liabilities that we have in the due course of time, within the specified period, right? Or the other purpose of declaration of solvency is that to declare that we have no debt or liability at all. So please let us wind up peacefully, right? And we have seen that yeah, it is accompanied by the affidavit and everything because that is a very important document, right? Because based on that you will decide what kind of proceedings or what kind of procedures will the liquidator follow, whether he'll continue it as members voluntary winding up or he will continue it as creditors voluntary winding up. So the fact behind the declaration of solvency is very important, right? So when the declaration of solvency is already provided, then 5 weeks hence you hold the meeting of the creditors, you hold the general meeting of the members, not the creditors, sorry, the members, right? Now what do you do in the meeting of the members? So basically when you have all the members on board, right, you are holding the meeting, what you do is you will pass a resolution that you need to wind up, and your resolution can be a ordinary resolution, it can be a special resolution depending upon the circumstance of the case. So if you are winding up because your object is over as per the article, ordinary resolution. You're winding up because the tenure is over as per the article, ordinary resolution. But if you're winding up for some other cause which is not provided in the article or somewhere, then you will have to pass a special resolution, right? Now okay, you have passed a resolution, whether ordinary, whether special, whatever the case may be, right, depending upon the circumstance. Now what? Once you pass the resolution, the winding up started, right? So when you are winding up the company, you need a person who would be capable enough to wind up the companies, who would be capable enough to carry on the procedures of winding up. So that is the liquidator, right? And since it is not the compulsory winding up by the court and the court has no intervention to play over here, the court will not send its official liquidator. So the members themselves have to appoint a liquidator for the winding up of the company, right? And that can be one liquidator, that can be more than one liquidator depending upon the size and circumstance of the situation, case and the company, right? Now when you are, one thing you need to keep in mind is that when you are appointing the liquidator, you will have to make sure that you fix his remuneration as well in the same meeting. with his appointment, because unless and until the remuneration of a liquidator is fixed, he would not take charge of the office. He is prohibited to do that. He cannot take charge of the office, right? And again, there is a rationale behind it. Why so? Give it a thought. I'll give you 5 more seconds to give a thought on why does the remuneration of a liquidator get fixed in the same meeting where he is appointed and not later on. I think the time is over. I'll tell it to you. See, consider a situation, right? The members, they have passed a special resolution all of a sudden one fine day that yeah, we need to wind up this company, right? I don't think we can go ahead very well with this company. There's some issues. I think we are losing the market. There's some other problem. But today, since we are solvent, we are able to pay off all the debts, right? Or any situation, we don't want to continue. Whatever be the reason, they passed a special resolution, right? And they called the liquidator. Okay. Now, in the due course, the members think that if the liquidator wants, and if he compromises on his ethics, he can give us some benefits. Like, there's a land, right? A land in Mumbai, a beautiful land of this company in Mumbai, sea facing, and there are some members who want that land. So what do? They will hit upon the liquidator. They'll say, dude, sell me this land at this rate, the cheapest rate possible. You have to dispose of the assets, sell it to me, put it aside. Sell this land to this person, put it aside. Sell this property to this person, put it aside. I mean to say that you can persuade the liquidator to sell off the asset at a price which is not at par with the market, because he's there to dispose of the assets and pay off the liability, right? So he can dispose of the asset at any rate. So you can ask him to dispose it off to you so that you acquire that asset at a cheaper rate. That is possible, and for that you say, okay, I'll give you 5% of the cost, and the liquidator is very happy. Okay. So what is happening is that you are inflating his remuneration. In the due course, when you come to know about something, what you do is you are inflating his remuneration. Or consider that you have a debt to the company and you are a contributor to the company, and you ask the liquidator, do one thing, make the call, ask all the contributors to pay the money, avoid my contribution, pay off the liabilities, you will have surplus. When you ask the liquidator to get into such activities, you will have to give him some share. And how do you give it? You raise the remuneration. So that is why you are not supposed to raise the remuneration of the liquidator once he has been appointed. And you will not delay in fixing his remuneration. You will say, okay, let's do one thing, stop. 10 days down the line, when everything is settled, accordingly we'll decide and we'll raise your remuneration. Even that is not allowed. Before he takes charge of the office, his remuneration has to be fixed. So that is the rationale behind the section saying that you have to fix the remuneration of the liquidator with his appointment, right? The other thing you need to keep in mind is that no body corporate can be added as a liquidator of the company. It has to be an individual, right? And the liquidator, whenever he is appointed, anywhere in the act, in this winding up chapter, wherever the liquidator is appointed, just remember that he has to send an intimation to the registrar within 30 days of his appointment. Everywhere it is flat 30 days, right? 30 days from his appointment, the registrar will be informed that yes, I am appointed. And then, when all these proceedings have been conducted very well, the liquidator takes charge of the office. And as soon as the liquidator takes charge of the office, the power of the board comes to an end. The board, they cease to act. Why? Now all their activities, all their powers will vest upon the hands of the liquidator. So anything that the director could do will be done by the liquidator. So the liquidator, he can use the common seal of the company, right? He can do all the activities, he can call the meeting, he can summon the meeting, he can get over to the management of the company, sell off the assets, pay off the liabilities, everything, the entire management will vest upon the liquidator. Right? But it is not compulsory that the board will lose all its power, which means to say that if the liquidator wants, right, then the liquidator can sanction the continuance of the power of the board. And on the other hand, even if the members want, Even they can sanction the continuance of the powers of the board. They'll say that board, please continue with your power. We need some of the help. We need some of the proceedings to be carried out by you. And we want you to help the liquidator. So in that situation only, in these two situations, when the power has been sanctioned, is when the board can carry on with its activities, can carry on with its powers. Right? Now we talk about the notice of appointment to the registrar and the ITO. And I would request you to pay a little attention on this part of the lecture, right? Because you might get a little confused if you are not attentive with this portion, right? So when we talk about notice of appointment to the registrar, right, then first thing that comes to your mind is that the liquidator will send the notice and that he will send the notice within 30 days from his appointment. Correct, absolutely correct, thumbs up. But the liquidator is not the only person liable to send an intimation to the registrar. The day the liquidator takes charge of the office, right, and the directors, they cease to hold their power, the directors will have to inform the registrar. They will have to send a notice to the registrar that for any further communication, for any further activity, for any further help, for anything you want to do further with the company, you should not be approaching us, you should be approaching the liquidator, because the liquidator has taken charge of the company and we have ceased to hold our power. Right? So the directors of the company who cease to hold their power will also intimate to the registrar, so that any correspondence made by the registrar will not be made in the name of the director, but will be made in the name of the liquidator. Right? So we have seen that the notice to the director, to the registrar, is sent, one by the liquidator and two by the directors. Now three, the notice will also be sent by the members, by the company. Right? When? One, when the liquidator is appointed. So within 10 days from the date of appointment of the liquidator, the company will have to inform the registrar that yes, we have appointed Mr. X as the liquidator of our company. Right? Now in the process of liquidation, if at any point of time, if the liquidator resigns from his office, then within 10 days from that resignation, or when anyways if the liquidator vacates the office, then within 10 days from that vacation of office, within 10 days from the arising of that vacancy, you will have to inform the registrar that yes, the office of liquidator now stands vacant. Right? Again, once the office of liquidator becomes vacant, what do? You appoint someone else as the liquidator over there. So within 10 days from the appointment of the other person as a liquidator in the place of the liquidator who vacated the office, right, when you fill up that vacancy in the office of liquidator, you will again have to inform the registrar within 10 days as to whom have you appointed. So in all these three circumstances, within 10 days you will have to inform the registrar. Right? And now let us also talk about the vacancy that arose in the office of the liquidator. So there can be any reason because of which there is a vacancy. The director left, the liquidator left, the liquidator was chased out, there's some uneven circumstances because of which the office stands vacant, right? Whatever be the reason. What we are concerned is that the vacancy has occurred, right? Then who is authorized to fill up this vacancy? Obviously the company. Just remember one thing. In compulsory winding up, members voluntary winding up, creditors voluntary winding up, whatever topic you're doing, remember one thing. Whenever there is a situation that you need to know who will appoint a liquidator to fill up the vacancy, then just see who had appointed the liquidator who vacated the office. The first liquidator, who appointed him? If the company appointed that liquidator, like in the case of members voluntary winding up, then the company would fill up the vacancy. If the court appointed the liquidator, in the case of compulsory winding up, then the court will fill up that vacancy. If the creditors appointed that liquidator in the circumstance of creditors voluntary winding up, then the creditors will fill up that space, that vacancy. Right? So just refer to who appointed the first liquidator, the liquidator who vacated the office. Right? Now, in this point we have also seen that the notice of appointment is sent to registrar and the ITO. But this is also a universal phrase in the entire chapter. Whatever kind of winding up you talk about, when there is a liquidator who takes charge of the office, then within the next 30 days he has to intimate the income tax officer of his appointment. that yes, I have been appointed, which means that the company is going to be wound up. So if you have any income tax liabilities pending with the company, please send me the details so that I can put some money aside to pay you off. Right? So you will send a notice to the ITO within 30 days, and then within the next 3 months the ITO will revert back. And the ITO will specify that yes, this is the amount that is due from the company, and then the liquidator will try to set aside that amount so that it is paid out to the government when needed. Right? Now, the next point of consideration for us is to call the creditors meeting in case of insolvency. Yes. Now, this is the situation that I was talking about in the beginning of the lecture, where the members' voluntary winding up converts to be the creditors' voluntary winding up. So, from this point, right, when there is a case of insolvency, the members' voluntary winding up comes to an end, because the base, right, the foundation of members' voluntary winding up was the declaration of solvency prepared by the directors. Right? Just because the company was solvent is that we went ahead with the members' voluntary winding up. If the company was not solvent, if the company did not have sufficient fund to pay off its debts and liabilities, then the company could not proceed with members' voluntary winding up. And in that case, they would have continued with the creditors' voluntary winding up. Right? So now, although they had started the procedure as the members' voluntary winding up, just because they had the declaration of solvency and they thought that they would be able to pay off all the debts and liabilities of the company. Right? But maybe now there are three situations. First, in the declaration of solvency, if the directors declared that the company has no debt or liability at all, and now you find that yes, there is a situation where some liabilities or some debts have popped up, that is the situation where the declaration of solvency goes for a toss. Another situation, when the directors say that yes, we have a lot of debts, we have a lot of liabilities, but we also have sufficient fund to pay them off. Right? Which means that all the debts and all the liabilities can be settled. Right? So when they say it can be settled, it can be in any period. It can be settled. And now you find out that there is no surplus fund with the company to settle up those liabilities. Or third situation, when they say that okay, as on date we don't have the money to settle the liabilities, but within 3 years time we will have surplus fund to set off all the liabilities. That means within 3 years we will be capable enough to set off all the liabilities. And then the 3 years have passed, but you could not set off the liability. That is when the situation comes into play. When we say that the insolvency situation for the company has arisen. Right? So what happens over here? When the liquidator sees that okay, the declaration of solvency that the director had prepared has gone for a toss already, and I have been continuing with the procedures of winding up as if everybody can be paid, so I just went on paying everybody. I did not focus on the preferential payment, the priority in payment. I did not call for the calls due from the contributory. I did not call for the debts due from the contributory. But now he will have to change his game plan. Why? Because his game plan followed the path of solvency, where everybody could be satisfied. So however you go, at the end of the day everybody is happy. But now his plan of action will focus on that insolvency point. And when he knows that yes, 30% of the liabilities cannot be paid, for example, right? It is a hypothetical example. So if he considers that okay, 30% of the liabilities cannot be settled, so what will he do? He will try and allocate the other 70%, right? He will try to adjust all the preferential payment and the overriding preferential payment in that 70%, so that if they are paid off, then even if the 30% is not paid off, it would not be a big deal. Right? So in that situation, now you will have to reassess the entire procedure and the entire planning that you have done. Right? And now the members will lose charge, the members will lose their power on the winding up, and the winding up will be continued henceforth as the creditors voluntary winding up. It would no more stand to be the members' voluntary winding up, right? And so, after this point, we have 2 points to be covered. One is to call the annual meeting when the winding up continues for more than 1 year, right? There is again one concept like that that we need to discuss, and the other is the concept of dissolution, right? After the winding up is done, how are the companies dissolved by the court? So, since we lack some time in this lecture, we will carry on with the same topics, that is, to call the annual meeting when winding up continues for more than 1 year, and also all the concepts about the dissolution of the company. Right? So, until then, this is Abhinay Gupta signing off. Stay tuned for the next lecture. Thank you and bye bye.